Welcome to our program of the Task Force on the Law and AI. And this program is a roundtable on generative AI practical advice for attorneys. I am Cynthia Cwik. I'm a vice chair of the ABA Task Force on Law and AI, and I'm head of the task force's working groups on generative AI, AI governance, and legal education. On this panel, we have several outstanding members of our generative AI working group who will share their considerable expertise regarding attorneys' use of generative AI in a legal practice. I have a few announcements to start with. The views of today's speakers may not represent those of the ABA and have not been approved by the House of Delegates or the Board of Governors. As to questions and answers during this program, we will have the Q&A function turned on. Please feel free to post any questions on the Q&A post. Questions will be answered live if time allows, and additional material will be available later when the video of today's presentation is posted to the task force website. A recording of this event is typically available within 1 week of the presentation on the ABA AI Task Force homepage. So today we're going to be covering several different important topics with regard to generative AI in the practice of law, including in understanding what generative AI is, exploring use cases, procurement considerations when acquiring generative AI products, policies for law firms, and cautionary issues, including bias, confidentiality, and IP. We have a stellar panel here today, and I'm going to be giving you a few highlights of the resumes of our panelists. Their bios will be available on the ABA AI Task Force website later, so you will be able to get more details concerning them, but I'll give you a few highlights right now. We have with us Maura Grossman, who is a research professor in the School of Computer Science and the School of Public Health Sciences at the University of Waterloo. And she's also an adjunct professor at the Osgood Hall Law School of York University, and an affiliate faculty member at the Vector Institute of Artificial Intelligence. And all of these are in Ontario, Canada. She's a principal at Maura Grossman Law, which is an e-discovery law and consulting firm in Buffalo. And recently, Maura's scholarship has focused on responsible AI and AI as evidence. We have also Dazza Greenwood, who's the founder of civics.com, which is a boutique provider of professional consultancy services for legal technologies, automated transactions, privacy, and data management and technology strategy. Dazza is also a researcher at MIT Media Lab and a lecturer at MIT Connection Science, where he's advancing the field of computational law and generative AI for law as executive director of law.mit.edu, as it says on his hat. We also have with us Lisa Lifshitz, who's a partner in Torkin Main's Business Law Group and chair of its Technology and Privacy and Data Management Groups. She has particular expertise in preparing, negotiating, and advising on technology agreements, including cloud computing, AI smart contracts, fintech, and blockchain contracts. She is the director and past president of the Canadian Technology Law Association and is co-chair of its Privacy and Cybersecurity Committee. Brian Beck is a partner at Zubra Lawler, where he focuses on IP and commercial litigation. His commercial litigation matters often include heavy technology and/or regulatory components. He has particular deep interest in new technologies, including AI, robotics, VR, AR, and quantum computing. And prior to joining Zubra Lawler, he practiced at Holland and Knight. And then finally, we have as our moderator, Karen Silverman. She is the CEO and founder of the Cantelis Group, and she's a leading global expert in practical governance strategies for AI and other frontier technologies. She was a partner at Latham & Watkins, and I had the pleasure of practicing law with Karen there for many years. She advised global businesses on complex antitrust matters, M&A governance, and crisis management. With that, I'll now turn it over to Karen.
Thank you very much. Well, since leaving you there, Cynthia, we really focused on technology governance sort of exclusively. So very, very happy to be moderating this panel. There is no technology, particularly the generative AI portion of this technology, that I think is going to make a bigger difference for how lawyers really practice, both in terms of accessing and improving things that are very familiar to us, and really showing us things that are very unfamiliar. And it's really going to be up to this community to help each other through some of those developments. And so for that, and to begin that, want to turn it over to Maura Grossman, who's going to give us a little grounding and level set on what is generative AI after all.
Thank you, Karen. I'm delighted to be here. So I'm going to give the 10-minute version of Gen AI, machine learning, natural language processing, the whole thing. So let's start with AI. The term AI was first used at a conference in Dartmouth in 1956, and it essentially meant computers doing intelligent things, performing what we would call cognitive tasks that require thought, reasoning, judgment, so on. And these were once thought to be things only humans could do, but all of a sudden computers could do them. So really it's whatever computers can't do until they can. And once we get used to it, we simply call it software. So it's magical at first, and then, once it's like spam filters or compare, it loses that magical property, and we call it software. So it's not a single technology or function. Those goalposts are constantly moving. And it's slightly different than automation and robotics. Automation is anything where a human is replaced by a machine. So your washing machine or your dishwasher are automation, they're not AI. And robotics is the hardware end of the scheme. So you can have robotic arms that are completely controlled by a doctor, but you can also have a drone that is autonomous and can make its own decisions about, if it has a weapon attached to it, who to shoot. Generally, when we're talking about AI, we're talking about algorithms, machine learning, and natural language processing, and I'll explain what those are. What's an algorithm? An algorithm is simply a set of instructions to complete a task. So a recipe to bake a cake is an algorithm. And when we talk about computer algorithms, we're talking about instructions to a computer to complete some kind of task, to do something. Whoops. Okay. So what's different about machine learning than prior types of computing is in the old days, if I wanted to do something, I had to program a computer and go through all of the steps of my algorithm and program each and every one. And then I had to change that whole thing into a programming language. Today, we don't have to do that anymore with machine learning. We can give a set of data to a system, and the system can infer the rules or the steps itself. So the first kind of machine learning is called unsupervised machine learning. We give the system a set of data, and it's going to look for patterns, reoccurring patterns, clusters, groups, anomalies, and so forth. And it is on its own going to separate the data into separate categories. So that might be Karen's personal email from her work email, from her online shopping, from her news, and it can do that automatically. But say I want to program a computer to distinguish between pictures of kitties and puppies. Instead of sitting down and listing puppies have ears that are bigger than kitties, puppies' ears go down and kitties' ears go up. But if it's a Jack Russell Terrier, the ears go up first and then flop over. I don't have to write all those steps down. I can give the system, here's a picture of a puppy, here's a picture of a kitty, here's a picture of a puppy, here's a picture of a kitty. And eventually, if I show it enough labeled examples, it will learn on its own what distinguishes a kitty from a puppy, and then you can give it an unlabeled example, and it will know. It can make a guess with high probability. But what if we have a more complex task? Say I'm Amazon and I want to deliver a package to Dazza today. Well, I know what packages he's received in the past, and I know what people in his neighborhood have received, but I don't know today. So I'm going to combine old data and new data. So that's called exploration and exploitation. Exploration is going to the new restaurant or into the new data, and exploitation is going back into the old data or going back to the old restaurant we've been to before. And the system will begin at random, but it's quickly going to learn based on reinforcement humans are going to give it. Good computer, bad computer. You got it right, you got it wrong. That allows us to deal with much more dynamic problems than just regular, plain vanilla supervised machine learning. You may have heard the expression deep learning. Well, think of deep learning as a stack of pancakes. And each pancake is a little brain or its own algorithm, and it's doing something different than the pancakes above and below it. So if we want to know what's in this picture on the left, the first layer may look at the pixels in the foreground. The second layer may look at the pixels in the background. The third layer, the colors. The fourth layer, the shadows, and so forth. And all of this is integrated at the top layer, where you can see vote 94%. So this allows us to do very, very complex tasks like autonomous vehicles, which combine sonar and LiDAR and radar and photography. And then at the top layer tells the car what to do in the next 5 seconds. The problem is it's very much black box. We don't know what's going on at all these lower layers. So everything I talked about up till now has been numbers, probabilities, statistics. In natural language processing, we're actually trying to build a model to understand and create language. So there's a whole bunch of tasks that go on, such as breaking up a longer string into its words and into sentences, looking for words that co-occur with other words that provide context and will signal meaning, looking where in a document words occur. If they're at the top of the document, in the title, they're more likely to be important than in a footnote, and building essentially a model to understand language, not like you and I would understand it, but a computer model. So let's get to generative AI. What is generative AI? It's a subset of AI that trains on massive data sources, primarily from the internet, and it generates new content in response to a prompt. So it falls under the broad categories of machine learning and NLP, which I just mentioned, and specifically it uses deep learning plus NLP. So there were 3 breakthroughs that led to the development of this new technology that came into, at least came into public awareness in 2022. It was available before then. The first were GANs, Generative Adversarial Networks, which is 2 algorithms working together. One is creating content, the other is criticizing the creation and comparing it to reality. And how this worked was it would generate an image of Karen. The discriminator will say, no, she doesn't have red hair. Oh, okay, let me try again. It would try again. No, she doesn't have blonde hair. And it would keep iterating until it gets really good and has a really good picture of Karen. And once that happens, it's very hard to distinguish the two because the discriminator has helped the generator get so good. This revolutionized audio and video and images. In 2017, Google introduced transformer architecture. So instead of having to label verbs, nouns, and all these things, we could have systems that read the entire internet simultaneously and learned all the grammar from all the grammar books. And we also introduced reinforcement learning with GPT-3, where humans would be behind the scenes saying, good answer, bad answer, or that's a good picture, bad picture. So that's what allowed us to get where we are today. And I just want to show you a couple of quick examples before I hand it over to Lisa. So here's text to text. I asked ChatGPT to give me a short Shakespearean sonnet about the Ontario judiciary. I'm not sure why the text is a little screwy on the slide, but you can see it can do that very easily. If I ask it to make it into a rap instead, it can do that also equally well. If I want to go from text to image, I can say, give me a picture of the Ontario judiciary in the style of Degas. We notice it can do that, but it's not very diverse. As a matter of fact, there are no women or people of color in the judiciary. If we ask for a Picasso image, we get, again, a fairly masculine Picasso image. If I ask again a third time, I can finally get a slightly more diverse version with men and women. And finally, the fourth time, after I say that judges, Ontario judges, can be of any race, gender, color, etc., I get a more diverse photo. But if you see in the lower left, the judge with the big pink tie, that's Gen AI trying to tell me that he's the LGBTQ plus judge. It didn't know how to communicate that other than through stereotype. And finally, we can go text to, it's not moving forward. I don't know why, but it stopped moving forward, whoever is controlling the slides. In any event, I'll stop here, but I did have a text to voice in the next slide, but the slides are not going forward anymore. So with that, I'll stop and turn it over to Lisa.
So actually, Maura, I've got some questions I'm going to ask you about section, and then we'll go on actually to Dazza next. But so these models that you've sort of walked us through, and thank you, I think that was set a land speed record for the, the history and background on AI and generative AI. They're massively powerful prediction engines, right? You had your 94%, certainty this was a boat, right? And we should all know that even the generative AI we're dealing with today are creating these sort of predictions about what a Ontario judge might look like, what a diverse panel might look like. They're really good at mimicking form. We saw that in your Shakespearean, effort and in your Picasso effort. Less good at generating content that we're confident is faithful to the intention. From your perspective, how do you think lawyers, particularly lawyers practicing with these tools, ought to factor these sort of characteristics of technology into their use of the tools, right? How do these technical characteristics translate to things lawyers should think about?
So we need to understand that when we ask ChatGPT a question, it doesn't really understand the question. It's building that linguistic model we talked about, but it doesn't understand in the way you and I do. It is giving us a response that it predicts is highly likely to be the right response, highly likely to be the next word in a sentence, highly likely to be a picture that we're looking for. But it can't assess truth and or fact and fiction and truth and lie. So it hallucinates, which means sometimes it makes stuff up. If it doesn't really know the answer to your exact question, it is just going to give you something that it found on the internet or saw on the internet or was trained on that is close enough in its view to what you asked. So to answer your question, we have to think about what use cases we use this for. So if, for example, we give it 2 briefs and say, generate a list of the questions the court might ask me in court based on the briefs that were submitted, it can do that well because it's got the actual briefs. But if you ask it, give me a case that says XYZ, unless it's a specialized tool that's been trained on case law, it doesn't know that particular case. It may make that case up. So it's very good for some tasks, particularly drafting, as long as you're prepared to edit, and creative tasks and styles and things like that. But unless it is either pre-trained on specifically on the law, or it uses something called RAG, which means that the system goes outside of itself to check things on the web or through other sources, then it's dangerous to rely on it for truth.
Thank you. Certainly in the first instance. And that's a perfect segue, Dazza, to your section where you're going to walk us through some use cases, that lawyers are starting to see, play with, deploy, right? So why don't you take it away? And I don't know if on the slides, if we can advance. There we are. Dazza, the floor is yours.
Great. Thank you so much. And I quite agree, Karen. That was a perfect segue from Maura with her basically her framing of how important it is to carefully consider the content that we provide to the model, because that is completely determinative, almost completely determinative of what the output will be. And that distinction in particular about asking the model for general information versus providing information and asking the model to work with it is what I want to highlight when we talk about these use cases of generative AI for law. So the very first thing is, we can go past this slide. Oh, hold on a second. Sorry, I'm getting used to driving Joey Gartner's slides here. It's a new interface. So when I say use case, it's a phrase that gets thrown around a lot. It comes from basically a way to describe and diagram technology. So it's not a bad word as an entry point to talk about the capabilities of this technology and to kind of map it to the types of tasks and processes and outcomes that we seek to apply it to in legal domains. This is what a use case technically is. It's called actors and actions. That's how we talk about them. Actors are like, the user, the organization, and they take action. So this is like the canonical use case for a technology system that also, by the way, is a legal system and a business system. It's an ATM machine. The actions you can take are check balance, deposit, transfer, and so forth. There's little arrows that can give you a sense of the direction of things. It's not a bad way to look at technology systems. Mind you, when we talk about use cases, they're like moments in time. To really understand this, you have to see it as part of like an overall flow, like a workflow. So to go back to Maura's example of like brief a case, for sure, you could say brief a case, you could give it the case and it will give you some thoughts about questions a judge might ask. If you were to zoom out a little bit to say, and here's my theory of the case, here's how I was battered recently on, or my client was battered on cross-examination. And here's some of the things we want to highlight and whatever else. And here's some of the weak areas in law, and here's some loopholes we want to exploit or what have you. You can start to see the broader context, and that's really important, not just for prompt design, but actually for understanding the whole system. But for purposes of this, let's just kind of get microscopic, and we'll look at some specific use cases. These are moments in time, like little value moments of how you can put a prompt in, get an output out, and utilize that as part of your law practice or for a legal task or process. Most important thing I want to just say for the third time now is you want to give it relevant context when we're dealing with legal usages of this technology. And this is critical because of the nature of this technology. So as Maura mentioned, it's very sensitive to exactly what the inputs are. In the case of like a search in Westlaw, we would just put a few keywords in and we would retrieve results based on those words. It's not sensitive to context at all. It is zero sensitivity to surrounding context. It's search and retrieve based on keywords and pattern match. That's very explicit to whether those words and phrases show up in the material. This is not like that at all. This is operating on deeper patterns of like the sort of the meaning and the concepts that are in the prompt, and it's matched up against a vast amount of knowledge in the training set, But if we want to get the highest quality output, we're going to have to tell it what our context is in these use cases. The way that we can tell it what the context is, for example, if we're briefing a case, we would give it the case and we would tell it how we want to brief it. Almost sort of like if you have a first-year associate that's come in that maybe knows a few things but doesn't know much about how to actually work yet. You have to sort of tell them a little bit about, what the task is and how to accomplish it. That's some of the surrounding context. If you want to review a contract, you give it the contract for sure, and you'll get something out. In other words, you copy and paste it in with a prompt. But if you really want to do is give it the client's contract playbook, or what your objectives are is in this part of the negotiation, or maybe past versions of the contract, and show where you're trying to go iteratively in light of where they've shown, where the counterparty's shown a willingness to budge. This is the sort of stuff you can add in to get more relevant and higher quality outputs on a contract review. It's what are you reviewing it for? For statute, obviously, you put the statute in, and you would also say context around what are we analyzing it for, or in light of what kind of factors. So how does this look in practice? So here's briefing a case. So I was saying, you want to tell it like, just in the simplest example, what method do I want to brief this case in? I'm using kind of toy examples here. This is like a law school example. If we're briefing a case for in the context of a client matter, we may want to be emphasizing other types of facets that we want to surface in each case to see certain patterns that align to our strategy or tactics in some situation. But that doesn't really change the use case that I'm highlighting here. The aspect of the use case is you say it out loud, or you type it explicitly rather into the prompt window. So I'm going to see if I can take a screen share here and give you like a live example on this one, and then we'll look at a couple of others. Should I just do the desktop? Yeah, I think I better, because we're going to go around some screens. And let me just triple check. Can you all see my screen? I hope. Okay, great. All right, so so first things first, I'm going to grab the stuff that we're going to use. So this is, oops, I'm on the wrong slide. Yeah, here we go. So let's say we want to use IRAC. That's what I usually used in law school. And what I did was I just went around literally just earlier this morning and found some cases in California that I might want to brief. This is a murder case. It's pretty chunky. So a way that you can do this is I'll put this into a text document so you can actually see the syntax. There's not any big magic to it, but you could say something along the lines of, here we go. So imagine this is in the prompt window, and it's about to be in a prompt window, but let me just decompose it first. Something like this is the simplest way. An instruction for the prompt up top. My instruction is, please brief the following judicial case using this method. And then I just copied and pasted the IRAC method. And then down here, judicial case. Something I want to explain to you for the use case of adding context in. This is very practical. Notice these weird little things here. There's like a hashtag and judicial case. This is just using a standard notation form called Markdown. And it just sort of shows the generative AI model that you have two different kind of blocks of text. You don't have to do that. I just like that. You could totally just do something like this. You just need some sort of delimiter so it can kind of see that there's different parts of the prompt when you're doing a two-part prompt, like here's the instruction and here's the context. You can have more context too. You could add in another component that does something like provide the prior communications with the judge, or provides what are we optimizing for, what's our trial strategy, or what have you. But let's just take this. I want to copy it, and I'm going to put it into a prompt, and let's see if we in fact get a reasonably brief case out. I'm using here, by the way, a kind of a neat service called, I'm not endorsing it, but I'm using a service called Poe, which I like because it sort of provides these windows into a bunch of different models. And so depending on if we have time or what happens, we can show the results from different ones. I'll use Claude 2 100K. The reason I'm doing that is because 100K it speaks to how many thousand tokens you can put through the window. So we want a fairly big amount of text that we can push through the window in this case, because I don't know if you noticed, but it was a pretty long murder case there. And so it's right now what it's doing is it's processing. It's doing this what Maura had mentioned, kind of going through these transformer models. And oh, lo and behold, what do we have here? Here is a brief analysis using the IRAC method: issue, rule, application, conclusion. Let's see if this is correct. I think this is right. I just kind of went through the case earlier today. Oh, interesting. Okay. Now, the other thing, so that's a way to use, that is a way to use context to do a simple kind of use case, such as brief a case. Similarly, for contract review, I think I sort of mentioned, you'd want to give it a contract and then also tell it against what criteria do I want you to evaluate this contract. So here's an example of that. I'll just go right back to that same sort
And
of.
Dazza, here you're going to want to also be careful about confidentiality, right? I don't know if you want to address that. Like briefing, yeah. Right. You wouldn't want to put client confidences necessarily in ChatGPT.
That's exactly right. Yeah. And so there's a give and a take with providing it the context. The more context you give it, including like all the context, all the relevant information, the much better the outputs will be. It really grounds it. You'll get little to no hallucination, for example, because it's now operating on it within the context window data that you have given it. It's not guessing what contract or what playbook you might have and inventing other facts and circumstances nearly as much. As a lot of research on that. However, the downside is the more context you give it, if you're providing that to an external party, you may be risking a violation of confidentiality or other, other ways to risk, high value, sensitive, or mission critical data that's protected in some way. So be careful of that. I've got a bunch of prompts where I'll go through and anonymize stuff internally before I use these powerful external systems when that's needed. The best thing I've been doing in industry through the consulting side of my business is just helping law firms and in-house counsel to operate a combination of open source models in-house where the data never leaves their premises, or using like external hosting providers where they already have all of their confidential data and it's already gone through security audit and they already have the right contracts. So like Amazon Bedrock is an example where a lot of law firms are already using Amazon Web Services. They have a sort of cluster where they can run models for you and so forth. Anything on FedRAMP is probably okay. But if you're just using what I'm doing here is nothing like that. I'm just literally going through like the public, everybody interface, which is exactly as Karen says, beware. However, I'm not so much focusing right now on those aspects. I just want to show you what it can do, and we can maybe go into some of the cautions and stuff around that in a little later. Because first things first, like, why is this any good? What can I do with it? And then let's get into that. So for this one, I'm going to do a prompt. I'm going to say, please, not review, please, not analyze. What is the task here? I guess I wanted to mark up. Please mark up the following contract. No, I'm just going to say review. Please review the following contract and evaluate it against the requirements of the below contract playbook. And then here's another thing that's really handy. You can actually instruct it on what you want the output to look at. First, give me a general overview in a paragraph, then bullet point list of violations, something like that. List of problem clauses and suggested amendments. Let's just go for the whole thing here. Amendments. Okay, so that is the playbook, and here is the proposed vendor agreement. By the way, again, to Karen's point, and I kind of promised I wouldn't get too much into things that aren't the use case, but I synthesized this playbook and I synthesized this contract. I was doing this for a client demo, and we realized that we couldn't use their actual contracts for the demo because, it was full of secret information, and we couldn't even use their playbook. So I just, based on doing a lot of contracts work over the years, synthesized a generally, reasonable looking vendor contract and a general, and a playbook that would have the sorts of things you'd have in a playbook. Like what, for example, I don't know, like procurement contracts, flat fallback positions, escalation points and stuff on liability, etc.
And we're going to get, Dazza, and we're very quickly going to get to Lisa, who's going to talk about some of the contracting stuff. So let's look at the results, and then I'll turn it over to Lisa.
You betcha. And here's the result. So it's literally gone through and it is highlighted what are the problems in the contract. Fixed pricing was a problem. Quality assurance, service level. I deliberately inserted a lot of problems in the contract so that it would find them. And sure enough, it's done. Notice how I instructed it to identify the problems. It's given me, because we gave it the relevant information, it was able to cite to the exact sections of the playbook that were violated, what the problem was, and provide an amendment. And that's all because of this. It's all because of the prompt. So in the use case, you want to give it a good, clear instruction. You can tell it what kind of outputs you want, give it the relevant information, and next thing you know, you'll be able to do things like, you could do that with e-discovery, mediation. It's been very helpful for statutory analysis and so much more. And so with that, I want to thank you very much and be happy to take any questions.
Thank you. Well, we're going to take the questions at the end. And I think, Lisa, let's turn it over to you to talk about some of the contracting provisions and sort of tips and tricks that you've already discovered in this area.
Thank you so much, Joey. If you can just get me to my slides. Thank you. Perfect segue, perfect transition, Dazza. Thank you so much for setting me up. Now I just have to figure out how to advance the slides. Good question.
Yeah, I think you can use the arrows on your keyboard.
Got it. Okay. Well, I am going to, hello everyone. I'm Lisa Lifshitz. I'm going to endeavor to cover in a whirlwind fashion all of the key contract hot button items that I've listed below. Needless to say, I will do my best. There are lots to consider in these contracts. As a general consideration, I want to start off with some quick observations and key transaction questions, focusing on the need to do your due diligence. Not all vendors are the same in this market, and then touch base on some of the key elements of these contracts. So starting from the top, these are obviously somewhat complex agreements. The services themselves are subject to constant change, and so are the contracts. I've given variants of this presentation before, and it's amazing how quickly the contract terms, I have to keep going back to make sure that what I put in here is current. So part of the challenge is making sure you even know what the terms are at any given stage. I actually see a lot of parallels to early days of cloud computing. It reminds me of Cloud 101. Right now, the contracts are very one-sided. They totally favor the vendors. They shift all the risks and challenges to the customer. And it's really a question of just doing the best that you can under the circumstances. And part of the challenge is even figuring out which contracts apply, because as there begins to be slow incremental progress on some of these points, you are starting to see differences between contracts aimed at individuals, contracts aimed at larger associations or organizations, and those that involve, that apply to quote businesses. Are law firms businesses for the purposes of these contracts? That's a really interesting question. So as I indicated, some general observation, the key thing is the most standard agreements are really silent on some very critical considerations. For example, making sure the models are maintained, making sure models are updated, making sure vendors have obligations to not use out-of-date training data. You would think they would cover this. They often don't. There's a really heavy emphasis on client responsibility. Like I said before, that's going to be one of the themes of this presentation. And they're silent on very critical vendor known risks, like, for example, confidential information, threats to privacy, cybersecurity. They may be covered in some alternative document, they may not be. And lots of disclaimers, particularly around reliability of outputs. So starting from the really key threshold questions, what are you going to acquire? What is your in-house department or your law firm interested in doing? Are you looking at some kind of, cut off the shelf version where it's plug and play? And those are the most pro vendor. If you're looking for something a little bit more developed using your data, for example, more bespoke, then there is more opportunity to influence the contract terms. You also need to consider the nature of the services the system will provide, whether it's using your data or you're training your own data. Will it be used internally or externally? Because that also makes a difference in terms of the focus of the contract terms that lawyers need to look at. And also whether or not it makes decisions that affect regulated decisions, as I should say. And also, are these meant to be international contracts or are they intended to be used locally? Another hot one is personal information, or as we say in Canada, or personally identifiable information. Are they using client data? Are they using internal data? What kind of data is it processing? And what control will you have over that processing? So a couple of key threshold considerations. Know your vendor. Is the vendor a relatively mature company or is it a startup? Is it something you're reading about in the newspaper every day? And I'm looking at you, OpenAI. Has it been the subject of lawsuits? Has it been the subject of publicly available complaints? What does the vendor itself say about the origin of their products and their data? Are they saying, for example, that they're going out, they're a trusted partner because they're using their own data that they've have all legal rights to, or are they publicly scraping this data? Was it created and meant to be targeted for government agencies? So the challenge here is differentiating the market. Not all of these vendors are appropriate for lawyers and law firms or in-house counsel. So that's really a threshold question, right? And you also have to know the use case, because before diving into the contract terms, how are you going to use it? How will it be used? Will it make decisions that are subject to specific laws? If that's the case, then you need to be mindful of the product and understand the contracting framework. So I like to say these contracts are like baklava. They're multi-layered, and you have to dive in and out of so many different versions, these ever-changing documents. There could be order forms, service agreements, separate terms and conditions, website privacy policies, bippity boppity boo. So you've got to read through all of this stuff, right, in order to really understand, because sometimes the meat is not where you would think it. It's not in the 2-page overframe document. It's in all those lovely hyperlinks that people need to read, right? Because what's interesting, of course, is a lot of them don't actually say when the contract changes, they just change them. There's no obligation to notify you, right? So regarding some of the critical elements now, data licensing and data ownership, you really need to understand what you're using it for, and then look to the license grants to make sure the vendors give you those rights. Because, for example, if you need the right to create derivative works from the product, then you need to actually see that in the license grant and look to see what they say about the ownership of the various components, because these are, interestingly enough, not all the same. So even in the product itself, sometimes there are changes and different license grants appropriated to some of these different elements of the services. Some of these actually have geographic limitations, for example, or you can only use certain elements of the services differently. And like I already mentioned, see what they say about where this data is coming from and whether or not, they give you you have all the necessary rights to use the systems with all the restrictions that you think you need. So moving to the vendor rights, and one of the other themes of my presentation is there's a lot of reverse onus, but there's also see what they say about their rights. So obviously most AI vendors really, really want to continue to improve their models, and how they do that is using customer data. So you need to understand what they're actually saying about your use of the data that you input, your client materials, your inputs, whatever you want to call it, because that affects issues relating to privacy and confidentiality. And also you need to get a feel for, are you comfortable allowing them to train or improve the model based on your content, right? And what does that, and also what are they doing with that content? Are they anonymizing it, or are they making it non-identifiable? You really need to understand that. And do you see if you have any concerns around that issue? Now, privacy and cybersecurity, of course, are absolutely critical for lawyers. So as part of the diligence, you need to see what the vendor is saying about that. Are they incorporating privacy by design? What measure are they taking to protect the data? That should be somewhere in their privacy policy, service terms, and things like that. However, the contracts themselves may not have what you need, particularly given your jurisdiction, depending on where you are. For a lot of them don't even touch mandatory data notification language. So you need to kind of understand what they say about that and amend those critical elements, and how they protect your inputs, client inputs. And also you want to understand if they're using sub-processors or subcontractors, because you'll look for the same thing from them. And as I mentioned, reverse requirements. So a lot of them say, oh, it's up to the client. Client, by the way, you have to provide legally adequate privacy notices. You have to make sure that you have all necessary consents to input the data. And by the way, sometimes they actually ask for representation. So look for those gotchas, because you may not be able to say that your organization or law firm is compliant with the GDPR, for example. I'm going to skip this slide in the interest of time. Getting to reps and warranties, typically as is, as available, with all the faults, utterly disclaiming everything. Maybe you get direct damages, maybe. And when you actually do, the actual value is extremely low. Here's an example too of reps and warranties, reverse reps and warranties again, telling everyone that they have to comply with, their terms, their privacy policy, any intellectual property rights, etc. So, lots of disclaimers. We have nothing we do is guaranteed. No reps or warranties, no promises that the service won't be interrupted, error-free, that your content will be accurate, secure, any of that stuff. Lovely, right? Why are we all doing this? So I give to you sort of the sorts of things that one should ask for. None of these should be surprising. You want reps and warranties regarding ownership, necessary rights, fit for purpose, conformance with your required specifications. You want to make sure there's no infringement. Compliance with laws is good. And also, no contravention of open source and other lawsuits, malware, spyware, third-party claims. And also, frankly, the more AI elements of this, because a lot of this is standard IT stuff, is making sure that they've actually talked about their testing and training. How do they do it in good industry practice? You also want to make sure there's reps and warranties regarding their documentation, and also things like this transparency and bias. Now, as I alluded to, disclaimers, there's some very funny ones out there. Funny only for lawyers, of course, $100 limits, 12 months, maybe of fees, very, very, very low limits traditionally. So this is one of those things, if it's important to your law firm, you really need to do a dive on this, because most people don't want to sign up, particularly in the business context, to such low limitation of liability. And, if to the extent that you are negotiating this, you need to tie it to a commercial deal, but you want to understand at least take a stab at recognizing that there should be higher caps than $100 for things like indemnities, breaches of confidentiality, compliance with applicable laws, fraud, gross negligence, and, typical multipliers would apply here. Interestingly enough, about indemnities, these are a double-edged sword. So most of these contracts actually have reverse indemnities, not what they're giving you, it's what you're giving them. So the challenge here is that some of them, they're really over the top. And they say things like, you're giving them indemnities for your access to or use of the services. Really? So there's a lot of sort of really read the fine print on these for the indemnity sections. If you don't take away anything else from this presentation, double check those indemnities, because a lot of them are really overly broad. Pretty much they are trying to cover off anything you do with their system or services, right? I mean, you get global indemnities in relation to how those services are being used. So again, these really do need to be limited. And, and to the extent that they are so-called new and improved, and they are starting to be a little bit better about this, there's a lot of exclusions. So that's another area where you need to make sure that, you take a hard look at these things. They're not so approved. So very briefly, because I know I'm timing out, you want to look and make sure that you are getting indemnities for the critical areas, breaches of law, IP infringement, confidentiality. You are beginning to see an industry thaw in this area. The larger vendors are actually publicly starting to commit. So this is the beginning, like I said, of a balance in the universe on some of these key contract terms. And again, on the indemnity side, you want to mitigate cross indemnities. Now, very quickly, towards the end, a couple of other points. Dispute resolution. Most of them are mandatory arbitration contracts at this point, which is offensive to some folks. But the other issue is look at the jurisdictions where the mandatory arbitration is. It may not be in the US, right? Some of them are in other countries. So if that's an issue for you, take note and revise them accordingly. On termination, you actually also need to understand, I should mention they terminate quite easily sometimes, but you also want to make sure what happens to your client's data, your data. Are they going to have a continued right to use it? Are they anonymizing it? Are you able to get your data back? This is really critical for lawyers and law firms, given considerations of confidentiality, et cetera.
So Lisa, I think that's a really good segue to the precautions section. And I just want to reassure everybody where the slides are going to be available at
Yes.
when the webinar is posted. So you don't have to be furiously taking notes here.
Yes, I was going to say that. That's great. Yeah, so just to get to the end, or just before the end. So one suggestion is if these are really critical elements for you and your organization, procurements are one tool you can use, for example, because that gives you the opportunity to internally understand your own risk tolerance and determine the critical issues for you, and B, put it out there that this is the requirements that you're looking for, and you can at least evaluate vendors, in a more balanced fashion on that. And the other issue is it will also tease out, if you frame it correctly, whether they're actually using AI, because to be honest, one of the other challenges these days, most vendors AI is here, and a lot of vendors are using it but not disclosing it. And this may cause you to have to, add some additional terms to your standard commercial agreements on that basis. So just
100%.
To head to the end. So, really, I'm a proponent of this, and notwithstanding this may sound a little anti-vendor, I do act for AI vendors too. We are in early days, and the key thing here is that don't be afraid to ask for changes. As I said, there's a lot of parallels to cloud. You will get some changes if you ask for them. And you also need to really kind of understand, the vendor and make sure that you are choosing the right vendor for your organization. And frankly, the standard off-the-shelf agreement may not be appropriate for your scenario, depending on how you're using it. So my point here is simply that it is very early days in this contract cycle, and I do expect that there will be some shift in the market as a result of consumer and commercial pressure.
Thank you very much, Lisa. And I think the other point you've made in other contexts is that very few of these provisions have been tested very much in litigation. So stay tuned, watch this space. Now, with all perfect wind up for Brian and precautions in AI, some of which I think were foreshadowed in Lisa's presentation. So Brian, you want to take it away?
Yep, both Lisa's and Dazza's presentation. So, Lisa's been talking about what you need to look for in contracts with these vendors and the provisions that you need to look for. And, the question that you may be asking yourself is, well, what are the things that could go wrong that I need to worry about the contract terms for? And, Dazza talked about some of the use cases and how things can go right. But AI is a powerful tool, but AI also has some significant inherent drawbacks. And what I want to talk about is how things can go wrong and things you need to watch out for to avoid disasters happening if you're going to incorporate generative AI into your practice. So the first kind of a fundamental problem, and this goes to kind of the initial part of what generative AI is and what machine learning is that there's a concept in computer science and other fields called garbage in, garbage out. all of this stuff all of this AI stuff is based on training data. You put training data in, you put some, you put the text works in or the images in that you're training on, and that is the training data that the AI system uses to create things. But if the training data is bad, then the output data is also going to be bad. If the training data has problems, the output is going to have problems. And that's kind of what this comic is pointing to in the slide, that if you train badly, you can get bad results. If you say, right, what the comic is talking about, if you train a robot to plan for war based on what happened in history, and hey, the majority of historical battles were fought using spears and rocks, then the robot may think that, then if you're training badly, if you don't do it right, then the robot thinks, okay, well, the weapons that we should be using are rocks and spears, and then the robot apocalypse is short-lived, as the comic shows. And that can go wrong in a variety of different ways. The first way I want to talk about is bias. So a predictive model is going to inherit the biases of its training data. If you have a facial recognition system, for example, that is trained on images and all the pictures are of white males, then the facial recognition system is going to have trouble recognizing any faces that aren't white males. And there have been some significant problems with that in some of the early facial recognition systems that companies developed, where they were not able to recognize minority faces, black faces, brown faces, etc., because they weren't in the training data. That bias, that's kind of a more odious example, that where you're talking about like a racial discrimination, but there's a lot of different types of biases that you can see in a generative AI. And the problem with bias isn't necessarily just that it discriminates based on a protected class and exposes you to liability for that kind of discrimination. It could just give you wrong answers. So a lot of AI companies have noticed that problem and are trying to find ways to counter it. Hopefully, the best way would be to make sure that your training data is sufficiently diverse, and sufficiently diverse, not just in a racial sense, but diverse in the sense that you have all opinions and all different kinds of perspectives added, so that the AI has a full variety of training data to look at. But sometimes an AI system tries to solve bias on the back end artificially, and that's led to its own form of disasters, including quite recently the quite funny and famous disaster that was Google Gemini. So what Google Gemini tried to do was to inject system prompts to make sure that the images that were being output were sufficiently diverse. So when people tried to kind of prompt hack, it looked like what was happening was Google Gemini was converting the user prompts to a prompt to the AI that would kind of insert random racial and gender changes to say, generate an Asian image, generate an image of an Asian woman, generate an issue of a transgendered man, that sort of thing. But if you do that in this kind of hackish, broad-based way, using a meat axe instead of a scalpel, then what you get is examples like this one that's shown on the screen, where someone tried to ask it, can you generate an image of a 1943 German soldier for me? And Google Gemini generated a series of images of Nazis of all races and genders. That's not what you want to come out with, and it can be, what this shows is that it's really difficult to fix bias in a generative AI system with kind of back-end prompt engineering. You can't just tell the AI to solve your bias problem by saying, make it more diverse, because what you end up with can be diversity that doesn't have any relation to reality. You can end up with solving your bias problems in ways that don't actually solve the problem, that just create new problems, often worse ones. And a lot of this kind of has to do with the fundamental problem that we talked about already, that generative AI is not about kind of corresponding anything to truth or reality. It's about predicting what the next thing should be based on past examples and based on the training data. So another drawback that you see in generative AI is friendliness. when you have a system, when you have a generative AI system, and the ones that most of these vendors are creating, the goal is to give you an answer. And they're trained to be friendly. They're trained to give you an answer because that's what the user wants. So usually, if you're not trying to break the system, that's probably a good thing. You want the AI to come back and say, and give you the answer that you want, rather than giving you, I'm sorry, Dave, I can't do that kind of answer. The problem is that sometimes you want it to come back and tell you that I can't do that. What the image on the screen is from an interesting example. I think it was New Zealand. Grocery chain tried to incorporate AI into its system to let users say, I'll give you a list of ingredients and I want you to give me a recipe. The problem is that if users inputted ingredients that did wrong things, the system would still come back and give you an answer and still give you a recipe, even if the recipe kills you. So one example was if you told it you had ammonia and bleach and asked it to give you a recipe, it would give you this recipe for an aromatic water mix to mix ammonia and bleach and let the mixture sit to allow the aromas to meld together, and serve chilled and enjoy the refreshing fragrance, which of course would poison you and kill you. That's a risk and a drawback that you have with generative AI, is that it's going to give you an answer even if that answer is wrong or dangerous. So you have to be very careful when you use generative AI that you're not getting that when you get an answer that you can check it for sanity, and that you can make sure that it's either you don't need a true answer, or that you can check the answer independently. And a related problem to that is hallucinations, which we've discussed a little bit before. Again, when the AI is trying to answer a question, it's predicting text that will answer the question. It's not actually answering the question. It's not looking to any source material necessarily to answer the question. It's not using the same process to answer a question that a human would. So what that means is that if you ask a generative AI system to give you cases or articles, it might just make them up. And the longer the answer, because when the generative AI system is predicting text, it's predicting based on the previous tokens. So the further you go out from the initial question, the more likely it is that you're going to start seeing hallucinations and made up things. And one example, and I'm going to go off the slides here and share my screen. Hopefully I can do that and come back without too much trouble. So take the use case that Dazza talked about earlier of briefing a case. And as Dazza said, the right way to do that is to have a system that lets you put in the whole case, so that you can copy the entire case text into the generative AI system and tell it, here's the case I want you to look at, summarize it for me. But let's say that you don't have Dazza's good advice and you are being sloppy, and you say, I want to brief a case, but I'm using the free version of ChatGPT 3.5, and I can't put in the whole case because ChatGPT 3.5 doesn't let me put in that big of a prompt. So I'm just going to tell it, I'd like a summary of this case, and I'm going to give it the citation. Hey, I'll give it the citation. It should be able to find it exactly. Citations are unique in the law. It should only refer to one case. And I tell it, use the IRAC model, explain the issue presented, rule applicable, etc. If I do that for a big case, like an example I gave here is parents involved in community schools versus Seattle School District Number 1, Supreme Court case, reasonably famous Supreme Court case from 2007. It gets it right. This is the answer ChatGPT gave me. I don't have time to read the whole thing, but the answer it gave is generally right, where it identified the right issue. The rule would identify that it's a case about busing and school integration programs, and the court found that the plan in the case didn't pass constitutional muster. But if I try this for a case that is not so well known, that is not as big, it can go off the rails. So I tried this with another case that is a little more obscure. Case called Liu versus Pricewaterhouse LLP, which came up in one of my recent cases. It's a copyright case in the Northern District of Illinois on the issue of whether a license for a software system can restrict the user's ability to claim copyright in the derivative work made with the software. And I asked it the same question for this Liu versus Price Waterhouse case that I did for the parents involved in community schools case. And again, ChatGPT gave me a helpful IRAC summary, but told me that the issue was whether the plaintiff could establish a prima facie case of discrimination under Title VII of the Civil Rights Act. I think it got confused with the difference with the Supreme Court case of Price Waterhouse versus Hopkins, which is close to that issue. But the case I was looking for was a copyright case, and the case that's cited here is a copyright case. ChatGPT got this 100% wrong. And if you use ChatGPT in a sloppy way, you don't give it the case ahead of time, and you think that it's giving you the correct case, then you're going to get an answer that is completely wrong. And if you rely on that, you could get in a lot of trouble. So if we can go back to the slides. Joey, I don't know how we get the slides back up. Thank you. So there have been a few cases, a few particularly famous cases where lawyers have tried to use generative AI to do research and incorporate into briefs and have been sanctioned for it. All three of these cases share kind of a common theme, which is that the lawyer used ChatGPT or another generative AI system for research, put the cases into their brief, and generally it was either a junior lawyer or the client who did the research, and then the senior attorney, the partner who put his name on the brief, then filed the brief without checking those citations, and it turned out the cases were fake. That was the case in all three of these situations. A junior attorney or the client, in the case of the Michael Cohen case, did research using generative AI, put them into the brief, partner files the brief without checking it, and fake cases go to the court, and then the judge, issues an order to show cause and sanctions the attorneys. What our managing partner at Zuber Lawler likes to talk about ChatGPT or other systems and describe them as a first-year associate who knows everything but lies. And that's why you have to exercise the same kind of caution as an attorney that you would with a junior associate when you're using this stuff. When you're using generative AI, you have to do your own site checking. You have to check things yourself before you file anything, because ultimately, if you're filing anything with a court or you're preparing a contract, if your name's on the work, you are ultimately responsible. You cannot pass off the responsibility for any of these mistakes to a junior associate or to the client or anything like that. Few other risks that you have to worry about: privilege and confidentiality. We've discussed a little bit earlier today. You can't reveal confidential information. You can't break the privilege. And this is a lot of what Lisa was talking about. Different AI terms of services may give the AI system the right to use content that you provide. OpenAI's terms of service, for example, appears to give OpenAI the right to use any content that you provide in a prompt. So if you're providing confidential information in a prompt to ChatGPT, then you are arguably violating confidentiality. You're violating your responsibility as an attorney. So if you're going to do anything that requires client confidential information, ideally don't you put it at all into a generative AI prompt. But if you have to, or if you're inclined to do so, make sure that you're using some kind of specialized system that keeps any of that client confidential information out of third-party hands. I think Spellbook, for example, has some precautions because it's specifically designed for law firms to avoid that kind of problem. Generally, this is the sort of thing you have to be cautious about and follow the advice that Lisa was talking about. Make sure you know what's in the contracts for the AI vendors, and deal with it accordingly.
And if I can just interrupt for one second, that's the difference, I should say, because Spellbook is intended for lawyers, and that's what they're marketing to.
Exactly. And then kind of a last precaution, and a big one, is intellectual property risks. So the training data that ChatGPT and a lot of these other systems use includes copyrighted material. And one of the questions there's the question for both the operator of the AI system: is the AI system infringing copyright by using copyrighted material in its training data? There's a trio of cases going on right now, at least a trio of cases brought by authors whose books were used in the training data. And a lot of those are still in the pleading stages. I think the Authors Guild case in the Southern District of New York, I think, may be the riskiest one at the moment for OpenAI. Includes a number of big name authors, including George R.R. Martin, who went into ChatGPT and had it generate summaries of their books to show that you can't generate a summary of a book if the book isn't in the training data somehow. So they were able to generate summaries of George R.R. Martin's books. They were able to have it generate a fan work called A Dawn of Direwolves based on as a prequel to the Song of Ice and Fire series. And that shows that there must be copyrighted material in there.
So Brian,
Yep.
Let's spin through this because I want to make sure we get back to what to do about all of this.
Almost done. There's a problem for the OpenAI system, but there's also a problem if you're a user of the AI system, that you might be creating a derivative work by accident. Right? If you are the one creating A Dawn of Direwolves, well, you're probably infringing George R.R. Martin's copyrights to do that. And there's also problems where the prompt may inject that. I just had a kind of a first-time example of this. I sent out a cease and desist letter for alleging copyright infringement on Monday, and got a response back from the adverse party saying, "We're very sorry. We didn't mean to infringe your copyright. We used ChatGPT, and what ChatGPT spit out turned out to be a copy of your work." I'm not sure I believe that, but that it's not implausible. I'm not sure I believe that in this case, but it's not implausible that could happen in a future case. Because there's copyright material in ChatGPT, you have to be careful that if you're incorporating some ChatGPT output into your work, that you're not accidentally infringing someone's copyright.
So exactly. So now we're going to turn it back to Maura. Thank you very much, Brent. We're going to turn it back to Maura to sort of talk about how we manage some of these risks so that we can get some of these benefits, which we've also sort of started to outline. So why don't we start with that, and then we'll take some questions at the end if there's time.
Thank you. So to speed along, you really should have a policy procedure, and training is critically important. You don't just say to people, it's okay, have at it. So let me talk about that a little bit. You want to first check with your insurance carrier and your local bar to see if there are any applicable rules or regulations, because if you're not if you're not covered to use this stuff, don't use it, obviously, because if you have an incident, you're not going to be covered. And there are 3 ethics opinions out so far: Florida, California, and North Carolina, worth looking at. They give guidance. So you want to define the scope of your policy. What tools are okay and what tools are not okay. They're not all created equal. Some of them have bigger context windows, allow you to put more in. Some of them, as we've heard, are open completely to the public and there's no confidentiality. Some are closed loop, so some are specially trained on law. What's covered, what's not? Who may use them, who may not use them? Under what circumstances may they be used or not? So you may want to allow people to use it for internal purposes, but not to send things outside the firm. What devices may they be used? There's at least one court now that is requiring all prompts be retained if Gen AI is used for litigation purposes. Well, if all these prompts are on somebody's personal phone, you're going to have a problem. So be sure you have that scope laid out. Then you want to definitely develop and deliver a training program. It must be mandatory. It's not, don't make it optional and let people decide they don't need this kind of training, they know better. And it must precede the work-related use. So at minimum, you should cover the basics of the technology like we did today, hopefully more than 10 minutes. Its capabilities and limitations, how to use it properly. You could spend a whole session on structuring a good prompt, as we saw. You want to talk about the ethical and legal considerations, including best practices for data handling, protecting privacy, confidentiality, the intellectual property issues that Brian was just talking about. And you want to give good examples of appropriate and inappropriate uses. For example, summarization and translation of lengthy documents, good use. low risk relatively. First drafts of routine internal correspondence or memoranda, brainstorming deposition questions, identifying legal issues or arguments, developing marketing and creative copy. Validation and verification are always required. Don't trust this stuff, not yet. It's just not there yet. Inappropriate uses, maybe generation of anything false or misleading, creation of deep fakes or other content that impersonates somebody, even as a joke. It's very easy for somebody to send something as a joke and it gets passed on and it's out of context, and then it's passed on to a client, and then you've got all kinds of problems. You don't want any violations of IP laws or regulations or infringements of any third-party rights. So don't say, please print out the first paragraph of the article written by so-and-so in today's New York Times. Not a good idea. It might very well give you that, and that's why the New York Times has brought a lawsuit, but you don't want to be involved if that's an infringement. No forms of harassment or discrimination. You don't want people using this without exercising independent professional judgment, supervising anybody else who's using it, checking the cases or any other source to make sure it says what the system says it says, and any other guidelines that violate the professional rules, like having a chatbot that's giving legal advice can get you in trouble, establish an attorney-client relationship when you don't mean to. You want to have regular monitoring and compliance because this tech is moving quickly. What we're learning about it is moving quickly. Policies need to follow along and change to meet the ethical guidelines that are coming out and changes in tech. You want to have a contact person for questions or concerns. You need to consider how long prompts are going to be maintained or responses, especially if you're in that one court that requires they be preserved, or if you're in a litigation where somebody's going to ask for them. Will there be disciplinary action if people violate the policies? Do you need to amend your engagement letter to tell your clients you're using these tools? Probably, especially if it's outside of your four walls and you're using it for more than just grammar checking and things like that. So what are those discussions that need to be held with clients? Not if you're using Grammarly, yes, if it's equivalent to outsourcing. And I'll stop there and pass it back to you, Karen, so we have a little time for questions and discussion.
Sure. And I just want to also just sort of observe that, at least in our work, one of the things that we're seeing is that there's a great deal of kind of hunger for information and support in this space, among the workforce, whether those are, lawyers and law firms or everybody else at the clients. And that there's a great opportunity here to do the kind of training and backgrounding that Maura's talking about in ways that actually really kind of scratch that itch, like if you do it right. So we're seeing a great deal of demand and willingness to show up for these trainings. And we're also seeing a great deal of success where some of these adaptations to policy are integrated into existing policies that employees are familiar with, right? So that it doesn't necessarily represent a whole new body of work. It represents a meaningful and appropriate extension of things they basically understand. I want to ask you, Maura, following up on this real quickly, in your experience or in your travels, and we can actually open this up to the rest of the group too, who within an organization is leading the AI governance and teaching work? Because I think the answer is not yet one role or person, but what are you seeing in your travels on this?
Oh, it's an interesting question because at some of the larger firms, we now have people with titles like Chief Innovation Officer, Chief Data Scientist, AI leader, and so forth. So sometimes the large firms are hiring people into very specific roles. But probably more commonly, you see a committee, as we did when electronic discovery first came out, and you had a committee that had people at all levels, from IT to compliance to to legal with an associate, a potential user, a partner. So I think having, you know, one of these multi-stakeholder committees is probably a good idea, because then you're going to get the benefit of all the different kinds of thinking and questions. But you really do need to have ownership somewhere. And it really may differ, maybe internally at a corporation, it might be compliance, but at a law firm, it's probably going to be some kind of committee.
Yeah, and I think even actually, frankly, in most organizations that we advise, it's some kind of a multi-stakeholder group with leadership that really is as senior as we can go with it, because I think the requirement that this work intersect with cybersecurity and privacy and data protection and all these, and you know, all these other equities, it really needs to be come from the top at a minimum.
Right.
And the
It's not pure tech.
yeah, and the training needs to include executives. This is not just reskilling and upskilling for everybody else. This is also an executive level function, is at least what we're seeing in our work. Wanted to double, there's one question we have here that somebody's looking to transition, or I suspect to sort of integrate AI into deposition abstract work. Does this group have any thoughts on how to ethically bill a client for a deposition abstract created by AI and then checked by a paralegal?
Yeah, I can speak to that at least to get us started. I was on the COPRAC working group in California that came up with some of the guidance on lawyer use of generative AI as part of the practice of law. I think Maura may have referenced that along with Florida and others. The way we addressed that was pretty simple, which was assuming you have a billing relationship with a client that is hourly, and you, let's say, save an hour on the development of those depositions, and you allocate 15 more minutes on checking them or something like that, then you would actually bill 45 minutes less. You bill for the time that you actually spent. And if you save time because you use the tool, you don't bill for the time that you save. You absolutely can, you know, service more clients and bill more time overall if you want, or do a better job. You could change your billing model. Is another thing that I think there's a lot of pressure for.
Fees. You could go to fixed fees for
That's exactly what I was suggesting. There may be pressure toward that, but I think the narrow answer to the question is posed is you only bill for the time that you spent.
Yeah.
And I'd add to that there's nothing really unique about that question to AI, right? If you wouldn't bill a client for the time you saved by writing out a brief in Microsoft Word versus penning it out by hand, right? It's just another form of technology that saves you time. And when you save time with technology, you don't bill the client for the time saved. You bill the client for the time you've actually spent after you've used the technology, and you know, you're passing the savings on to the client. You're not getting the benefit yourself.
Well, and it's interesting that I think clients are still, experimenting as well. Some are going to be insisting that their counsel use these tools. Others are going to be prohibiting counsel from using these tools. And some of that turns, I think, on the kinds of things that Lisa was talking about with, you know, what's going to happen to my data? How are you going to pool that data? Who owns that data? I mean, there are a lot of really interesting underlying questions about how outside counsel in particular can deploy client data. We have another question. This is about the recent Air Canada AI-enabled chatbot issue. This is a fabulous little vignette. A customer went to Air Canada's website to ask about bereavement fares. The chatbot made up a policy that didn't exist and provided that to the customer. It also linked Air Canada's real policy, which was on the website. The customer relied on the erroneous, or sort of the fabricated policy created by the chatbot. That resulted in a claim against Air Canada for not honoring the false policy, and the tribunal said that AI was responsible for this over Air Canada's objections, trying to blame the chatbot, right? And the question here is what can be done to guard against this? I think this falls in the category of sort of buyer beware, but do you guys have thoughts on, you know, from the perspective of the Air Canada?
I actually wrote an article on this. It's currently sitting on the Business Law Today website if folks want to read it. So I read the case. It's a fascinating little case because the lawyers attempted to argue, I have no idea why they did this, that the chatbot was a separate legal entity. and therefore Air Canada wasn't responsible for them, which was absurd, right, on so many levels. And by the way, it's a tribunal decision. We're not talking by US standards. I think they really owed him like 650 Canadian, which is like $1.50 US. I mean, it was absurd, right? So at the end of the day, though, I think it highlights two things: a bit of the arrogance of that particular entity, because honestly, they should have tested and trained their model better and verified the minute they realized there was an error, rather than arguing this, like that, just pay him, right? And so instead, this particular little tribunal decision of the BC tribunal made headlines across. It was reported by the Washington Post. It was reported by the New York Times. I mean, you couldn't ask for worse publicity. And sort of, you know, again, just a caveat emptor. Obviously, this illustrates in a certain respect the downfall, or not the downfall, but it's early days in terms of some of this, right? And so they just should have verified that the information was correct and moved on, right?
Also, if you look at the date on the case, it was right when ChatGPT came out. So my guess is the tech was not a large language model. It might have been an expert system. It might have been some more primitive system that had an old policy that wasn't updated. I agree with Lisa. You're kind of scratching your head and saying, why on earth did they argue it the way they did? But it may actually have been an older tech.
I agree.
In fact, it was an old. Oh, excuse me.
Yeah, go ahead, Dazza.
Oh, thank you. In fact, it was older tech, which I think is really interesting. In some ways, I feel that this case is just the case we need now in order to have this panel to talk about, you know, how to deal with this technology. On the one hand, they claimed it was, you know, the program was its own legal entity, like some autonomous robot, and so it's liable for itself. On the other hand, they weren't even using generative AI, which is a cautionary tale, because as you said, Maura, when you use generative AI, we can expect an even broader array of hard to predict answers. And so the way I look at this is, I think in the US context, and this is also pretty similar under Canadian law, we have a legal framework that we ought to apply when we're utilizing technology as an agent on our behalf, and it's Uniform Electronic Transactions Act. You know, I went to every drafting meeting of that, and like we did a good job. It was back in the 90s. It's still good law, 49 states and all the territories. And it says when you have an electronic agent, which these chatbots are, and you're doing an automated transaction of some kind when it's doing stuff without human review or approval, and the acts of that agent are attributable back to the party that's deployed it. Okay, so exactly, you know, the tribunal did a good job. What that means is new safeguards and protections are going to be essential to ensure that you can stand behind what the outputs of the generative AI are when they're acting in an agentic fashion. And there's ways to do that, but I think the main thing is be very, very careful when you're exposing this probabilistic technology directly to the public to speak on your behalf. On the other hand, it's really powerful for some automated transactional systems. So we just launched a project at law.
But we're running out of time, so I want time to do a lightning round, Dazza, so real quickly. Okay, so first I'm going to tell the audience, you feel free to reach out to any of us on LinkedIn, connect with us that way. What lightning round thing that you're most excited about with this technology, like no more than 15 seconds so we can get to everybody. Maura, what most excites you about this technology?
The creative applications, the being able to, if you can't draw, being able to draw something pretty amazing, like look at the Sora video that's coming out now, and it'll take your breath away.
Yep. Lisa?
Potentially increased efficiency and automating some of the more mundane aspects of what lawyers do. So,
first cause for celebration.
Exactly.
Dazza?
Well, and it's the same as what I would have said a moment ago. I think these agent-based uses are the most exciting. They're dangerous. And for more on that, look at law.mit.edu/agentic, where we just launched a project to see how to do this safely.
Great. And Brian?
Maura kind of took my answer. I'll add brainstorming to kind of artistic stuff. You know, one thing I think is funny about the way that generative AI has come about, we had this whole idea in our novels and arts that, you know, robots and computers could, you know, make tasks more efficient and do stuff, but they never really have that. They'd never be able to create a work of art. They'd never be able to write a poem. And it turns out that it's actually the opposite. The AI the AI systems we've got right now are often better at creating poetry and art than they are at getting accurate and truthful answers. So I'm really excited about the use of AI for creative tasks, almost more so than I am about the use of generative AI, at least as it exists now, for things that require accuracy and truthfulness.
Well, I think in one way, shape, or form, all of you have observed the same thing, which is that these tools, as we sit here today, are good at automating tasks where we really know what good looks like, right? These are regular tasks we do a lot of, and we know what we're looking for. And then they're really good at, inspiring and generating kind of novel combinations of things. But it's sort of that vast middle ground where most stuff happens, where we have to stay really, really vigilant. And with that, I want to thank all of you as panelists. It was just a joy to do this today and to prepare to do this today with you guys. And to thank the audience for sticking with us for 90 whole minutes. I know there's much more to talk about, and I'm sure we'll be back. So Cynthia, anything from you? You're on mute.
On behalf of the ABA Task Force on Law and AI, I want to thank this terrific panel. I think that you provided some extremely useful information for our participants, and we're very grateful to you for the time that you spent. And you can look at the ABA Task Force website to find out about upcoming events. So thank you all very much.
Thank you.